Good morning, everyone, or good afternoon, depending where you're watching this webinar. Welcome to the second part of the International Arbitration in Latin America, the State of Play, organized by CAM-CCBC in partnership with the Colombia International Arbitration Association. My name is Natalia Negret, and I am CAM-CCBC's Institutional Development Advisor, and I promise I'll be very brief with this introduction. Patricia Kobayashi, our Secretary General, have already stated this in the welcome remarks of the first part of the webinar. But I feel obligated to say it again, that on behalf of CAM-CCBC, I would like to thank Gustavo Von and Camila Simão, who's also moderator for today's event, and the Colombia International Arbitration Association for putting all this work together. Also, thank you the Colombia LLM candidates that participated in the organization and also promoting this incredible event. We very much appreciate the institutional support of Canal Arbitragem, or Arbitration Channel, if I may. And last but not least, I thank all the panelists for the availability to be here in this sunny Friday, at least in São Paulo, it's sunny, to discuss the developments in the field of arbitration in Latin America. So without further ado, I wish you all a great webinar, and Camila, please, you may have the floor.
Thank you, Ana Flavia, and good morning to everyone. I'm a LLM candidate here at Columbia Law School, and it's a pleasure to be able to moderate our first panel today, where we'll hear from Silvia Pachikoski and Caetano Berenguer on the Brazilian scenario. I would also like to thank CAM-CCBC in the names of Ana Flavia, Patricia, and Silvia, who is here, and the CIAA, especially Gustavo Von and Canal Arbitragem, for organizing this event. We had some amazing panels last week, and we'll continue to hear from exceptional practitioners today. Now, before we get into the Brazilian panel, I just want to quickly introduce our panelists. I could spend the next 30 minutes just talking about their experience, but given our time constraints, and since I think it'll be more interesting to hear directly from them, I'll just give very short introductions. So Silvia is the Vice President of CAM-CCBC, and she's also a partner of the dispute resolution practice at Elia Batista Advogados. And Caetano is a partner at the litigation and arbitration practice of Sergio Bermudez Advogados, and he's also a former Columbia Law School LLM. They both have exceptional experience with international and domestic arbitration. They have been recognized by prestigious legal publications and legal rankings, and it will be a pleasure to hear from them today. Now, since the Brazilian Arbitration Act has just turned 25 years last year, I wanted to start by asking our panelists, what are your views on the development of arbitration in the past 25 years? And also, what are the obstacles that arbitration still has to face, or the new obstacles that have arisen in the past few years? And I think we can start with Caetano, and then Silvia can answer.
So, thank you, Camila, and I'd like to thank CCBC and also Colombia for this invitation. As you said, proudly I am an alumni of Colombia, so it's a great pleasure to be here with you today alongside Silvia in this panel. So thank you for the organization and for the opportunity. So. Going straight to your question, arbitration has grown immensely in Brazil over the last decades. This is pretty unanimous, I think, and statistics also show this. Of course, that there's still room for growth, but it has indeed grown a lot, and with the support of the legislation and also with the support of the judiciary in Brazil. There has been, with respect to legislation, there has been major and important changes in the law over the years. Actually, Silvia would speak better than me about this, considering the role that SEBAR and herself had in also important institutions to make sure that the good projects go forward, but the bad ones are completely banned from the law in Brazil, and this is a very important work that has been done in the past years in Brazil. With respect to the judiciary, institutionally speaking, I do see a position in favor of arbitration in general. Now, we see important precedents from the higher courts and also lower courts that have been officially become specialized in arbitration matters in Brazil. Of course, that there are exceptions. One interesting one happened yesterday. We saw in the news a justice from the Supreme Court making random comparisons between arbitration and judiciary in Brazil. But I do see this as an exception, not as a rule, and definitely not something institutional from the judiciary. I do see a position in favor of arbitration. When it comes to obstacles, Camila, there are important ones to be overcome. One of them, which is not a new one, is the issue of duty to disclose from the arbitrators. Now, we've had in the past important precedents in this matter, but we still do see some relevant disputes nowadays, major and relevant disputes nowadays dealing with this matter. And the way I see is that this limit of disclosure, and in my view, there must be a limit, not only needs to be matured and discussed, deeply discussed in arbitration forums as this one, but also by the judiciary, because the judiciary in the end is where you are defining and ruling these matters of potential violations of disclosures. This, for me, for sure, it's a hot topic to be discussed, at least in Brazil. But I would like to hear Silvia on that as well. And one other one is the issue of transparency, for sure. This is definitely not an easy issue to be discussed. And this issue includes transparency of decisions, awards rendered by tribunals, but also about the arbitrator, him or herself. I mean, the cases that they're involved, number of cases, the panels that they compose. So there have been measures taken by institutions. For instance, CCBC and also ICC have been adopting important measures in this regard by publishing reports with decisions and awards, and even a list of the arbitral panels that are being run before them. So to me, these are the two topics that I see that arbitration faces in Brazil, at least the major ones that Brazil faces in arbitration nowadays.
Thank you, Caetano. May I, Camila? Thank you. Hello, everyone. Good morning. Good afternoon. Well, I would like to do some overview coming on the last 25 years. So I believe there is much to celebrate in the last 25 years of the Brazilian Arbitration Act due to the stability and the respectability of the institute in the country. However, one cannot forget the path taken from Brazil to become an arbitration-friendly nation, and moreover, a protagonist in the global arbitration scene. And it's, however, important to recall that shortly we wait 5 years for the Supreme Court to state the constitutionality of the arbitration law. So we wait until 2001 to have this confirmation from the Supreme Court. And then in 2002, the New York Convention was ratified, transferring the recognition and enforcement of the arbitral award from the place where it was issued to the state where it will be enforced, removing the double exequatur required before, which ensured greater legal certainty to international arbitrations here in Brazil. And since then, arbitration here in Brazil achieved a leading role, as mentioned by Caetano, having reached the 3rd place in the ICC ranking of the countries using international arbitration. Such success was due to the timing, the speed, expertise of the arbitrators, the confidentiality and flexibility conferred by the arbitration. Of course, our judiciary, who carries more than 200 million process claims there, also contribute, because speed and the expertise of the arbitrator is a great value here as a place to discuss the issues of the company. So in 2015, the Brazilian Arbitration Act was reformed. The new law just incorporate some practice established by case law. So it was very important to recognize the decisions from the Superior the Superior Court bringing to the law these practices already established and already stabilized. As an example, and a very important example that we had, and the changing of the law was the possibility of the government, the public administration, to use arbitration as a means of conflict resolution, which led to the promulgation of subsequent regulations. And more recently, I believe a very great goal that we had since the beginning of 2020, the pandemic has made the arbitration community move in order to ensure that ongoing cases continue and that new cases could be initiated. So I am very proud to say that CAM-CCBC, as an example, quickly issued normative resolutions which regulated the possibility of conducting cases remotely, tailoring the practice to the social isolation enforced then. And it's very important to mention that the fear that we had before in means of security and the possibility to move to the digital system, but the pandemic ended with this drama, and now we are doing very well in this new system, and virtual and physical, and everything is going very well. On the other hand, among the obstacles faced by arbitration in Brazil, we can mention that even in 2002, we recognized the New York Convention. There is a lack of application by the Superior Court in actions for the recognition and enforcement of arbitral awards. In such case, the Superior Court of Justice has been applied other provisions like its own bylaws, the Civil Procedure Code, and the Brazilian Arbitration Act itself. This practice does not consider the positive impact of the application of the New York Convention on the perception of legal certainty by the other signatory countries of the New York Convention, a relevant aspect concerning international trade. And moreover, as mentioned by Caetano too, I believe the indiscriminate presentation of challenge of arbitrator as a crossroad for the reform of arbitral awards from their annulment has been a new obstacle faced in Brazil, which we can observe, for example, in the cases like Abengoa and Eldorado. I believe, Camila, this is a quick overview what we faced on the last 25 years here in Brazil.
Thank you, Silvia and Caetano, for this first overview. Now, considering the growth of arbitration, Silvia, I wanted to ask you, one of the areas that might need innovation and that has been discussed is class arbitration. It's not discussed just in Brazil, but it's growing. And I wanted to ask you, what do you think are the main challenges from importing a collective proceeding to arbitration? And do you think that it is feasible to have class arbitration in Brazil and even desirable?
This is a great query, Camila. Collective arbitration, I believe, has great potential to foster access to justice, says through the union of efforts, resources, cost sharing. It allows the participation of individuals who alone would not be able to resort to arbitration due to its high costs. In Brazil, collective arbitration is governed by the same set of rules applicable to collective lawsuits, given that they consist in rules of public policy whose application is mandatory. Such set of rules has some particular characteristics that also apply to arbitration proceedings. Naturally, the path is still obscure and of course needs to be regulated. Some obstacles can be overcome more easily, such as the publicity of the proceedings, the disclosure of its existence to third parties. But in my point of view, other issues are more challenging, such as unitary and mandatory joinder of parties, extension of the effects of the res judicata to third parties, parties representation itself, borrowed evidence, consolidation of proceedings, and introduction of new claims. So this is just a few examples among many existing challenges. So in order to avoid further discussions, I believe it's worth mentioning that while the regulations of the arbitration centers are not adapted to cover the main challenges concerning collective arbitration, I believe such issues can be regulated by the company's arbitration agreement. So until then, many collective arbitrations will be initiated and the judiciary may intervene to help to help settling any controversies. So despite these challenges, this lot of challenge that we have, in my view, it is very beneficial, the use of collective arbitration, but we have a huge path to go into, still go into. So I believe it is the overview that I have.
I think that those are some interesting propositions that we'll have to consider moving on. But I wanted to change a little bit now the topic, because last week we heard a lot about investment arbitration in Peru, Chile, and Mexico. And while we don't have investment arbitration in Brazil, as Silvia already mentioned in her initial overview, the Brazilian public administration can enter into arbitration, and it is allowed to submit disputes to commercial arbitration. And so, Caetano, I wanted to ask you, what should one expect when arbitrating with the public administration in Brazil? How has it been your experience with arbitration and the public administration? Has it been working well, and what are the practical hurdles that you have seen?
Thank you, Camila. Actually, this is a very good question. Well, we've seen a significant increase of the use of arbitration by public administration recently. And we do notice at the same time a certain effort from public entities to be more involved in arbitration proceedings. From a practical point of view, we've seen this movement. And public prosecutors and public attorneys have been specializing themselves in the area and even actively participating in seminars and debates related to arbitration. But to me, the point is, for this to work well, the public administration needs to be comfortable with arbitration, and also needs to see the advantages of it. And this is a process, for sure. One good example that we had the privilege of participating, it was the Maracanã Stadium case in Rio. And there was a considerable advantage, even for the state of Rio de Janeiro to have this case held in the arbitration and not by the judiciary. It was a very complex case, and it took 3 years to be resolved before the arbitral tribunal. And in this very same case, with the complexity it carries, it would take easily from 7 to 10 years to be resolved in courts in the state of Rio de Janeiro. So this is a good example that we saw that even the public agents saw the benefits of having this case handled by arbitration. And this goes beyond the interest or the final result of the arbitration. It goes a lot on the timing. So having an empty stadium in Rio for years because it's still in dispute, this is bad for the public administration, and this is bad for society in general. So this would be one example. In terms of practical hurdles that you asked, and sometimes you find some hurdles that seem to be minor, but they compromise in the end the whole arbitration proceeding. One example that is very interesting. It's related to costs. So as you know, in Brazil, when a public entity litigates before a court, they do not have to pay costs until the end of the proceeding. So they do not need to ask for authorization or for even to have any payment during the procedure. This is not the reality in arbitration. So what happens in practice is that if the opposing party, the private party, does not anticipate the costs in favor of the public entity, the arbitration just doesn't move on. So it compromises the whole procedure, because in the end, if you're not able to pay and the opposing party is not willing to pay, then you would have to go back to the judiciary, and it compromises arbitration. So we find these very common hurdles that seems to be minor again, but in practice they're not. But in the overall, I should say that when public entities are guided by a technical drive and not by a political one, arbitration has indeed played an important role in resolving disputes in Brazil.
Thank you, Caetano. I hope that it is the technical drive that keeps moving the public administration. And while we have seen a growth with cases involving the public administration, when we look at the statistics of the main institutions in Brazil, and CAM-CCBC has some great statistics on that, the main subject that is discussed in arbitral proceedings here in Brazil involves, in a way or another, corporate matters. And because these proceedings usually involve the interests of third parties, I wanted to ask you both, starting with Silvia, how do you see the role of confidentiality in these proceedings, especially given the CVM's, which is the Brazilian Security and Exchange Commission's proposal for public companies to disclose information regarding arbitration and judicial proceedings? And if you have any other comment on the particularities of those kind of disputes, just feel free to chime them in as well.
Thank you, Camila. We are in Brazil, I believe, worldwide, because it was on 2019, the last ICC meeting in Miami. It was part of the speech as the importance of transparency and confidentiality versus confidentiality in the arbitration procedure. So I believe the first important thing that it's important to clarify is that the Securities and Exchange Commission, the CVM's proposal, is restricted to disputes that involve diffuse, collective, or individual homogeneous rights or interests, or that could affect relevant third parties such as investors. It does not aim at completely eliminating confidentiality from the arbitration proceedings, but instead modulating its effects in special cases where public interest is involved. The proposal, therefore, aims at guaranteeing more clarity and legal certainty for market agents, which is desirable vis-a-vis recent cases that had negative repercussions, such as the one involving Petrobras. I believe Caetano can tell more about it. However, it's necessary to find a balance between the rights of shareholders and third parties to access information and the particularities of arbitration. And therefore, I believe that some adjustments to the proposal are due. In this sense, it's important to define what information can be disclosed in order to avoid potential adverse effects, such as damage to dynamics of the arbitration procedures, exposure of companies, and unnecessary price fluctuations once the claim or the arbitral procedure came to be known by everyone, increasing regulatory compliance costs and characterization of competitive disadvantage in relation to other markets that do not require the disclosure of arbitration proceedings. We cannot create two kind of market was we can generate damages for the public sector. So my opinion is that confidentiality should not be completely eliminated, but rather adjusted in order to accommodate the interests of all parties involved, as well we did in the case with the public administration. So we give the necessary information to allow the publicity, but you do not open absolutely the confidentiality of the cases. So with regards to the arbitration proceedings initiated by minority shareholders, their publicity and impacts on other shareholders and the company itself constitutes, this is for me, the challenge to be overcome. Similarly to the collective arbitrations issue, the solution lies, again, on the adjustment of the arbitration center's regulations and on the drafting of the arbitration agreements. I believe to try to reduce the noise on these issues. Meanwhile, the centers are not already done. Meanwhile, CVM does not regulate properly the situation. The companies can take care of his own arbitration clause in their bylaws to avoid this kind of issue of claims, etc. Thank you.
Thank you, Silvia. Maybe they can follow the example of the public administration having a website to publish certain information. Caetano, do you have any quick comments here? I think you're muted. There you go.
Okay, now I go. Just some quick comments. I fully agree with Silvia's point. And as I said before, this transparency and public access discussion is not an easy one, much to the contrary. But the way I see this is that perhaps we are choosing a path here that places confidentiality undermined or in detriment to publicity. And the difficulty here is to give the right dose and the correct dose to this change. Think of this in practice. Just one example, if you give public access to an award related to a major dispute in Brazil, even if you hide or delete the name of the parties involved to preserve confidentiality, of course that the whole market and the players involved will know and will easily relate that specific dispute and that award to the parties. So again, as we see in this example, maybe we're putting confidentiality at stake, perhaps for a greater need or good, at least in the corporate world. But I am aware of the details of the project that Silvia mentioned, and the critics related to it, many critics. But I do, on one hand, understand the difficulty of implementing this project, and on the other, the need of the market, for example, to have access to arbitral precedent, which is something very difficult nowadays still, and it's something to be discussed. But again, we would not definitely need more time to elaborate on this hot topic here and to discuss in length.
Thank you, Caetano. I think all of the topics that we're discussing here could generate their own webinars. But since we were discussing shareholders arbitrations, this kind of arbitrations generated some recent conflicts of jurisdictions between the judiciary and arbitration recently. We've had 2 conflicts of jurisdictions where shareholders filed arbitrations against the federal government, and the Superior Court of Justice ended up deciding that they should be decided by the judiciary. So I wanted to hear you first, Caetano, on do you think that those recent decisions by the Superior Court of Justice have affected the Superior Court of Justice approach to the negative effect of competence? And also, what are your views in general on the conflict of jurisdiction? Because I think it's something very particular to Brazil.
And okay, so as I said before, my view is that usually and in general, the higher courts tend to apply and to preserve arbitration principles as the competence principle, and to respect the jurisdiction of a certain arbitral tribunal to decide its own jurisdiction in the first place. There are exceptional precedents in this regard, as we know, that the judiciary applies when sees a pathological, and that's the used term, the pathological illegality, serious enough to exclude the competence principle in a specific case. But this is exceptional and definitely not the rule. But this understanding and this guideline of the judiciary, it was not the case, however, of the arbitration that Silvia mentioned before about the minority shareholders of Petrobras, in which the federal government could be condemned to pay over 100 billion reais to the company in Brazil. And since it is a very important case, this went to the judiciary to decide in a conflict of jurisdiction procedure, as you mentioned, Camila, and the judiciary decided that the federal government was not bound by the arbitration agreement. I must say here, I must disclose that I am completely biased to discuss this topic because I act on the case. But to me, the rulings so far were completely wrong from a technical standpoint. The federal government was the one who proposed the inclusion of the arbitration agreement in the bylaws. The federal government voted in favor of such inclusion in the bylaws as the majority shareholder of the company. And even though the judiciary ruled that the federal government is not bound by the arbitration agreement. This was the decision and hopefully will be reversed in the judiciary. But on the other hand, I must say that from a procedural standpoint, I do not see this case as a violation of the competence principle. And this is, and the reason, I'm sorry, the reason for this is that in this specific case, there was a prior award from the arbitral tribunal recognizing its own jurisdiction, its own competence in the case. And only after that, it was overruled by the judiciary. So whenever there is a case of conflict of jurisdiction between a court and an arbitral tribunal, according to the Constitution of Brazil, the judiciary is the one competent to decide finally which tribunal has jurisdiction. So at least in Brazil, the one to give the last decision is the judiciary, and this happened in this specific case. So to me, although wrong and incorrect in the merits of the jurisdiction issue, it's not really a matter of a competence principle violation. I hope I had answered your question, Camila.
You did, thank you. I'm also biased in this case, so I agree with you, but I wanted to see if Silvia has any comments on this topic as well.
Thank you, Camila. In fact, I don't think there is a change of approach from the Superior Court. Again, Brazilian Arbitration Act expressly authorized governmental entities to choose arbitration as an adequate means to settle disputes concerning pecuniary matters. To do the theme's novelty, several practical aspects remain controversial, and the arbitral tribunals often have to deal with issues concerning subjective arbitrability, confidentiality, publicity of the arbitration proceedings. So with regards to the arbitrability itself, one can note that the number of incidents of conflict has substantially increased. So my view on the role about conflicts of jurisdiction, they are an important instrument for preserving the integrity of law and due process. As mentioned by Caetano, courts are entitled to control the validity of the arbitration award. So if a case is submitted to an incompetent authority, all acts performed by it may be rendered null, resulting in loss of time and money by all individuals. Therefore, if such situation can be avoided at an early stage of the proceeding by means of a conflict of jurisdiction, it's obviously more advantageous. However, it's worth mentioning the bad part when it's used with a view to delay the proceedings. So this is, I believe, the bad use. It is the bad part. So last Wednesday, a very important decision regarding a positive conflict between two arbitral tribunals was rendered by STJ, and the conflict 185-702. I believe Caetano is biased on this case also, which the existence of a positive conflict of jurisdiction between two arbitral tribunals conducted by the same institution has been recognized. So the remedy is unprecedented. For the first time, STJ has to decide this kind of conflict between two arbitral tribunals in arbitration proceeding conducted by the same institution. I don't know if Caetano has more information and wants to comment, because I know you are in the case, so it is involved the JBS's company minority shareholders, and the other arbitral proceeding is started. So they allege the conflict of jurisdiction based on the fact that both arbitration proceedings have the same object, cause of action and plea, and that the decision is issued in such proceeding were the opposite when related to parties' legitimacy and the effects of res judicata. So the decision has in injunction suspended both arbitration proceedings presented by the minority shareholders, in which the arbitral tribunal had rejected the JBS's request motion to dismiss and determined that JBS should be subject to the final decision of the arbitral award. So let's wait for the next chapters, but I believe that STJ will have a clear view of the importance of the decision and a technical movement and not a political decision.
Okay, then before we move on to the last questions, do you want to make any quick comments here?
I'm gonna be very quick here, Camila, and thank you, Silvia. Yes, and just not to take too much time here, it's very interesting. It's this role that the STJ is taking in this other case that we are, but the difference here is that here we're not between public jurisdiction and arbitration jurisdiction. We are here discussing two different arbitrations and which one should proceed according to the STJ, the one filed by the minority shareholder or the one filed years after by the company itself. But it's still interesting to see how the judiciary plays this role in a technical manner, and as Silvia said, I hope that the STJ gets this right in this case as well.
I hope so too. Now moving to our last question, because I know we're short on time. One topic that we discussed throughout all of the questions was transparency and disclosure, and we have seen an increase in the number of challenges to arbitral awards regarding failure to disclose information, and if that could allegedly impact the arbitrator's independence and impartiality. So Silvia, I wanted to ask you, how do you think that these decisions impacted discussions on arbitrators' disclosure in Brazil? And if you want to throw in any last remarks, please go ahead.
This is the hottest topic in Brazil about the challenging of arbitrators. So the most common ground for challenging an arbitral award is the alleged failure of arbitrators to fulfill their duty of disclosure. So the arbitration community has been placed on alert, and its players are being more cautious in order to avoid such accusations. Individuals appointed to act as arbitrators are being more diligent, I believe, meticulous in the analysis of facts that may cast doubt on their independence and impartiality. So we have been used instruments like the IBA rules to guide the extent of the duty of disclosure, as I'm seeing becoming increasingly frequent the use of the IBA rules. And the challenge to arbitrators have become a true reflection of an increase of guerrilla tactics. This is the worst scenario. Parties dissatisfied with the outcome of the dispute try to annul them before the judiciary under the pretext of an arbitrator's failure to comply with his duty of disclosure. Their allegations are often groundless, as in the Berenguer case, for example, as well as Eldorado case. But I believe it's important to note there is no presumption of bias. Any doubts concerning an arbitrator's independence or impartiality must be based on undisclosed fact and analyzed according to objective and temporal criteria. It's important also to highlight that even though the number of challenges to arbitral awards are increasing, the judgments that effectively uphold plaintiffs' claims are the minority. Thus, I believe it's safe to state that the Brazilian judiciary remains favorable to arbitration, with no signs that this scenario should change in the future. So what is happening sometimes is they have a very first decision, suspending the discussion or suspending the execution of the award, just to understand what really happened. And this is doing a lot of noise, like, hey, they stop the proceeding, they continue to see it, but it's natural once the court is the one who control the arbitration properly. So I don't think it's something to stress or to say bad about arbitration in Brazil, but it's something that we, the ones who act as arbitrators, we are taking more care about what must be disclosure or what does not be have to be disclosed. So what is important and what is not that important to be disclosed. So it is a highlight, a yellow light just for taking care. I don't believe it's a changing of mind.
Thank you, Silvia. I think we have some complex issues to face in Brazil, but hopefully it will be a favorable path moving forward. Caetano, do you have any final remarks in like 30 seconds?
No final remarks. Again, I would like to thank you, Camila, Gustavo, Vaughn, for the organization, CCBC Colombia, and especially Silvia. It's been a pleasure, a huge pleasure to be sharing this panel with you.
Thank you, Caetano and Silvia. It was a privilege hearing your views on this Brazilian scenario. And with that, I'll give the word to Natalia, who will now conduct the Colombia panel.
Thank you, Camila. Thank you, Caetano. A pleasure. See you.
Good morning to everyone. First, I wanted to thank you and to thank especially to CAM-CCBC, all the speakers and my classmates at Columbia Law School, especially to Gustavo. Today, I'm happy to introduce two leading figures from the international arbitration world and practice in Colombia. On the first hand, we have María Burgos, who works at the Baker McKenzie office in Bogota. She has been recognized as a future leader in this area of practice for 3 consecutive years by Who's Who Legal, and she has more than 10 years in international arbitration, without doubt a leading figure. And on the other hand, we have Mr. Eduardo Zuleta, who is a star in international arbitration in Colombia. Mr. Zuleta has acted as chair and co-chair and co-arbitrator, under the ICISD, under ICC UNCITRAL rules in both investment and commercial cases. He also is the vice president of the ICCC and has his practice also teaching at Georgetown University. The first topic that I would like to go through with my two co-nationals will be the monistic and dualistic structure. In Colombia, we have the dualistic approach towards international arbitration, and we find difference in crucial issues as the non-arbitrability. My question would be, and María Angélica, could you take the word first? What effects dualism have on the overall effectiveness of international commercial arbitration in Colombia? And the second one would be if there is a way to overcome any problems of non-conformity that might be brought about by dualism.
Thank you very much, Natalia. It is truly a pleasure to be here today in this conversation with you and with Eduardo. Thank you to CAM-CCBC for the invitation and to the Colombia International Arbitration Association. So in regards to your question, as you mentioned, Natalia, indeed, in Colombia, we have a dualistic regime. This means that we have one set of regulations in the law for national and domestic arbitration and a different set of regulations in the law for international arbitration. The law in the international arbitration chapter is primarily modeled upon the UNCITRAL model law. And the difference or the main impact is that the existence of these two regimes presupposes different conditions and different requirements for both types of arbitration. Colombia has a lot of, is very active, I believe, in domestic arbitration. And we also have a very interesting movement of international arbitrations, both seated in Colombia, and also we have seen in the recent years several recognition of foreign awards under our law, the arbitration statute, with this international chapter. So your question basically refers to the fact of arbitrability. And this is a very interesting point in which perhaps the conditions and the characteristics of the dual system can be evidenced, because precisely the question of arbitrability, or at least of objective arbitrability, that is, which disputes can be subjected to arbitration, has been highly debated in domestic arbitration. We have seen these over the years and through several different forms of legislation, interpretation by the courts, decisions. Some of these issues have been decided. The criteria that applies today for domestic arbitration is that we can arbitrate, or we're allowed to arbitrate, everything that is disposable by the parties and those specific matters upon which the law authorizes parties to arbitrate. So this concept about what can be disposed of by the parties in turn has also been interpreted. Generally, we say rights of economic content generally can be arbitrated because, of course, they can be disposed by the parties.
We have several specific points that also have been a matter of discussion. In our prior panel, we heard from our colleagues from Brazil about the disputes of shareholders. This, for instance, has been something that in the context of domestic arbitration in Colombia, we have also seen highly debated as to whether certain types of disputes can be in fact arbitrated, and this has been decided via the courts. And even so is the matter of additional discussion in the context of a potential reform to the law. So taking upon or building upon this discussion in the context of domestic arbitration, we go to what we have in our dualistic or in our regime for international arbitration. And in international arbitration, we do not have a provision or a legal provision similar to the one as we have in domestic arbitration to determine which types of disputes can be arbitrated. I think this comes from the fact that we are premised, or that our law is premised on the model law, and the model law gives a lot of deference to states to decide the questions of arbitrability, specifically in the context of what are the grounds for annulment and what are the grounds, or in the application of grounds for annulment and in the application of grounds for recognition and enforcement. The only provision we have says that nothing in the arbitration statute will be deemed to contravene the provisions of domestic law as to what can be arbitrated. So what we have seen in practice is that the decisions of the courts, of the Supreme Court of Justice and of the Council of State have taken upon the notion of arbitrability in domestic arbitration. So it's very often that you see in the decisions that, well, in this case, we see that there is arbitrability and that this is a dispute that can be arbitrated because it is a right upon which the parties can freely dispose of. So until now, we have basically, although we have different regimes, we have basically used the same criteria to determine what disputes are arbitrable under Colombian law in the context of domestic arbitration as in the context of international arbitration. So I think that's a response to your initial questions.
Thank you, María Angélica. Eduardo, we would like to hear your thoughts.
Yeah, I fully agree. I would make just a couple of remarks. Number one, Colombia is, in terms of dualistic approach, the extreme in Latin America. International arbitration and local arbitration are totally apart, have nothing to do one with the other. And people in Colombia have been trained in domestic arbitration. Law schools and chambers of commerce train people in domestic arbitration. And then international arbitration in those courses is treated as a sort of a special category of arbitration together with labor arbitration, administrative arbitration, IP, whatever. So that, in my view, is making very difficult for youngsters, and María Angélica knows that very well, to jump from local to international arbitration. Somebody who has been trained in local arbitration is very difficult. It will be very difficult for that person to jump into the other. And the second thing is that sooner or later, as we feared when the law was drafted, there have been overlaps between domestic and international arbitration. And as María Angélica was pointing out, theories that apply to international arbitration being applied, that apply to local arbitration being applied to international arbitration, because that's what people know, what people have been trained for. So I think we can overcome that and at least close the gap between the two regimes soon, because it is affecting arbitration in Colombia, definitely.
Thank you. So the second topic would be, like, the Colombian Constitutional Court recognized the possibility of obtaining constitutional injunctions against award issued by international arbitrators seated in Colombia. The decision was rendered by 3 justices, and even though it didn't grant the injunction in that case in particular, the court upheld the possibility of challenging international award on constitutional grounds. Under these circumstances, Eduardo, I wanted to ask you, how does the Colombian constitutional injunction, the tutela, against award compare with similar constitutional protections in other regions of Latin America as the amparo?
Again, we have the dubious pleasure of being the leaders in what a tutela should not be, an amparo should not be. Countries in Latin America decided at a given point in time in history to include arbitration in the constitution as a way to protect arbitration against attacks by the judiciary, against attacks by the politics, etc. So they took the guidelines of the Spanish Constitution And based on the Spanish Constitution, the different countries adopted different approaches. I would say the most advanced approach is Costa Rica. Costa Rica has the right to arbitrate in the Constitution as a sort of a fundamental right. It's one of the rights of the individual, the right to arbitrate. So there's no dispute. The dispute would only be amongst what is the category of the right to arbitrate if compared to other categories of fundamental rights. And the only other fundamental right that could be compared there would be due process. I don't see any other thing. So that is one extreme. The other extreme is Colombia. In the middle, you have Mexico. Mexico has arbitration again in the Constitution, but simply providing that the parties may go to arbitration. And the reason for that is to avoid this discussion as to whether the fact that the Constitution provides that the exclusive jurisdiction to decide conflicts is on the judiciary, then arbitration is unconstitutional. So Mexico solved the problem by simply saying in the Constitution that the parties may agree to arbitration. What Colombia did, in my view, was totally wrong. But what we did was to include an article in the Constitution elevating arbitration in the same category of the judiciary. So if you look at the Colombian Constitution, arbitration is to some extent, and the way it has been interpreted, is part of the judiciary of Colombia. And that has very dramatic effects, as I will say. Now, this particular decision of the Constitutional Court is problematic, and it would seriously affect, I would say, Colombia as a venue for arbitration. Because the decision of the Constitutional Court, on the one hand, in my view, was unnecessary. All the court should have done is to say, we cannot hear the amparo because there is an annulment pending, period. That's it. That was the core of the decision, was to reject. But they decided, in the guise of rejecting, to take two approaches. The first one, to consider and reiterate, because they have already said that in the prior case, that international awards issued in international arbitrations are subject to the amparo, to the tutela action. That in itself is totally different from any other region or any other country in the region. In the other jurisdictions, either amparo is not available, or it is only available against the decision not to annul or to annul the award, but not against the award issued in international arbitration. And the second point, which in my view is the most problematic, is that the Constitutional Court indicated that the amparo in the case of awards in international arbitration is excepcionalísimo, very exceptional. Now, what is the difference between exceptional and very exceptional? Whatever the judge considers is exceptional or very exceptional. But since the court said that this excepcionalísima, or this category of very exceptional, is because the arbitration law provides for violation of public policy as a ground for annulment. So the court said only those grounds that are not included as violations of public policy could be the subject matter of a tutela. The problem is that one of the grounds that would not be subject to the public policy rule is the case in which there is a violation of a substantive provision of law. And the court has said that there are situations in which not applying a law that is applicable, applying a law in the wrong way, that could be the subject matter of a tutela. So the end result of this decision is not only that the amparo is open, the tutela is open against international awards, but that the merits of the case can be reviewed, which is unique with respect to the other countries in the region. There's no other jurisdiction where this decision has been taken. Fortunately, it's just a decision of, as Natalia was mentioning, 3 members of the court. It's not a decision of the whole court. And we expect they amend that because, again, that would seriously affect Colombia as a venue for arbitration.
Thank you, Eduardo. María Angélica would like to add or remark something on this topic.
Yes, just a very brief point. The decision that was commented by Eduardo and Natalia is a decision from 2019. I have come across a decision from the Supreme Court of Justice of 2018, which actually is, I think it's interesting for the purposes of the discussion we're having. It was a case of an international award in which the law applicable to the case was Costa Rican law, but the tribunal was seated in Colombia. And there was a request for tutela or amparo presented before the Supreme Court of Justice, which was admitted and afterwards decided against. They did not grant the relief requested, but they admitted the decision. So it's even interesting because one of the things that has been debated is that if the applicable law to the dispute is not Colombian law, then we might not be in a case in which the tutela should be considered. But in this case, we had Costa Rican law with an arbitration seated in Colombia in a tutela decided by the Supreme Court of Justice. And this is a case of 2018. So I do think it's a topic which of course has been highly debated. It's quite controversial and upon which we would need to continue this conversation and to have further decisions on the courts to provide guidance as to how to apply this towards the future.
Yeah, I think I just to add on what María Angélica was saying, which I fully agree. In the decision of 2019, one of the things that the court says is that the tutela is applicable where Colombian law applies to the case. So can you imagine a case where, as María Angélica is mentioning, the applicable law is Costa Rican law, but the arbitral clause is governed by Colombian law. So it would be a tutela just against the clause, but not against the merits of the order. It's totally absurd. I don't know what the merits of the case have to do with the tutela action at all.
Thank you, Eduardo. Our third topic would be the reality, and trying to connect with what Eduardo said before, that the Colombian Constitution provides arbitrators are comparable to judges. The underlying idea is that the awards have the same effects of judicial decision, and in that regard, under Colombian law, arbitrators are acting within the scope of the appointment, but administering justice. María Angélica, I would like to ask you if you could walk us through the recent case law in arbitrators' liability and what are the effects of these decisions.
Yes, thank you, Natalia. Well, this is also a very interesting, controversial, and debated case. It's from last year, October, and it's in the context of a domestic arbitration. So again, this touches upon the initial thoughts that we were having and exchanges about the dualistic regime. So in the context of a domestic arbitration, what happens is that one of the parties submits a complaint in the administrative jurisdiction before the Council of State, stating that it has a right to be indemnified because of the damages caused by the judiciary branch on account of the decision of an arbitral tribunal, not on the decision of the court vis-a-vis the annulment, nor on the tutela decision, but on the decision issued by the arbitrators in the award. In the context of this decision, the State Council analyzes whether, in fact, what we call in Spanish responsabilidad del Estado, which is a very specific institution regulated under our Constitution, on account of the actions of the arbitrators. And the conclusion of the majority is that the judiciary branch of Colombia can, in fact, be liable towards parties, towards individuals, for damages caused by mistakes or gross mistakes, in this case, gross mistakes committed by arbitrators when deciding cases in which they have been appointed as arbitrators. So it's a very debated case precisely because it touches upon other issues which have also been discussed in that, not only in Colombia, but in the region, as to what is the responsibility of the arbitrators, but specifically about the fact that arbitrators can trigger responsibility for the state. And the fact that the state, although not responsible or not supervising the decisions and the actions of the arbitrators, would eventually be in a position in which they could be liable towards third parties, towards private parties, individuals, for the actions of the arbitrators. So it has been, as I said, this is a decision in the context of domestic arbitration. Nothing in the decision suggests or refers to it being applicable specifically to international arbitrations. However, there is also a very important point made by one of the judges of the Council of State who separated his opinion from the opinion of the majority, stating that in his view, this was absolutely inapplicable because arbitrators could not be considered state agents. And he gave a lot of prominence to the fact that arbitration is voluntary and based on consent. So the fact that parties decide voluntarily to go to arbitration, appoint their arbitrators, they choose them, then they cannot come after the state afterwards to claim responsibility for the decisions of those individuals. As I said, this has been a quite contentious point. It has been very controversial and given rise to a lot of debates because it could potentially expand the scope of the responsibility of arbitrators and the responsibility of the state, and eventually even result in a decision by the state to say, well, this was not what we intended when we allowed people to go to arbitration for certain types of disputes, and we will not have this liability or this risk of being responsible later on or having to repair damages to parties on account of the decisions taken by individuals who have been authorized by the Constitution to act as arbitrators. So it's a case, I think it's very interesting, and it's like I said, an ongoing debate and conversation in the context of arbitration in Colombia today.
Thank you, María Angélica. Eduardo, I would like to hear your thoughts from the stance of the arbitrator on this subject, and please go through.
Two or three comments here. The first is, as María Angélica was pointing out, if you put arbitrators in a position of being liable for their decisions, or the state being liable for the decisions of the arbitrators, but the first thing that could happen, in addition to the effect that María Angélica has already analyzed, is that in an investment case, or an investment case could arise as a result of a decision of a local tribunal of arbitration. And there will be this decision of the Council of State, which in the theory of attribution is already saying that the arbitrators are agents of the state. So you would prove the attribution by a decision of the court, of the Council of State, the highest administrative court, which is nonsense. The second effect, of course, from the point of view of the arbitrators is, and María Angélica already suggested that, I would not like to arbitrate in Colombia if that is the effect. And I know Colombian arbitrators that do not want to arbitrate in Colombia, that they prefer to arbitrate outside of Colombia, because the role of the arbitrator in Colombia is so controlled, so ruled, and the liabilities are so high that it is impossible. It is impossible to act as an arbitrator when you know that you can go from being liable or the state going against you if the state results liable from your decision, to, well, criminal complaints. We have seen that. We in the future, the way the trend is going, we will have to study criminal arbitration law. So I think is a very bad decision. Again, I hope that sort of decisions are reviewed. And the comment on that, the last comment on that, and on this trend of decisions, is that we need to provide judges with text and with information and with, I don't want to call it training because judges hate that word, but with material for them to realize that international arbitration is a totally different animal, and they have to understand, to analyze international arbitration from international rules based on international treaties, and not the rules of the Code of Civil Procedure, which is basically what they continue doing.
Thank you, Eduardo. For me, that's like the most important thing, in the sense that when you constitutionalize arbitration, you open a gate that every single judge that doesn't know, that doesn't have the knowledge of the international law and the international rules or the underlying industries go and comment, and we have this kind of disputes and realities in the arbitration which are not pro-arbitration at all.
Yeah.
Our fourth topic would be the criteria for annulment. And this is another difficult path that we have in Colombia, in the sense that the Council of the State and the Supreme Court of Colombia have independent case law where you find discrepancy in the annulment criteria. The disparity, of course, has an impact on the safeguard of the award. And in any kind of legal system, we need certainty to indeed to provide positive climate for investment and commercial transactions. So Eduardo, can you please share your views on the effects of this discrepancy and elaborate on what are like the grounds for having that discrepancy?
Okay, the background of this, to put this in context, when the arbitration law was drafted back in 2012, the commission thought that it was a good idea to separate annulment and have annulment before the Council of State for arbitration involving state entities and before the Supreme Court for arbitration between private parties. The practice has shown that it was not that a good idea. The Supreme Court has been very constant and very international, quote unquote, had a very international approach, both in annulment and in recognition and enforcement. The Council of State, first, this is to put additional context. This is the same case that gave rise to the tutela action that I commented before. In this particular case, after tutela, one after the other, then the Council of State finally had to decide whether to annul the award or not. And the key issue there was whether the violation of a procedural rule would give rise to annulment of the award. The trend in international and comparative law and international courts, the trend is to consider, and I think is an adequate trend, and is the same trend that you find in annulment committees in ICSID, that you can annul an award based on a procedural violation, provided that the procedural violation, if not committed, would have had an impact in the award. In other words, you cannot simply say any procedural violation, simply because it is a procedural violation, would go to the annulment of the award. The Council of State created a very creative, for the pleonasm, a very absurd theory, but because they say, if we analyze whether the lack of compliance with the procedural rule would have impacted the award, then we will be analyzing the merits of the case. And I think it's totally wrong, because the standard is not whether or not the other party would have won the award. The standard is whether or not the violation of this particular rule would have had an impact, whatever impact on the award, period. And that does not mean getting into the merits of the case. And I can give you an example. Let's assume that the parties agree that the submissions would have to be made in footnote with I don't know, font 12, space, 1.5 space, etc. And one of the parties does not comply with it. What impact does it have in the award? None. Is a violation of a procedural rule? Well, yes. So what the Council of State should have done is look at the materiality of the violation. And if you look at the decision of the Council of State, and if you look at what happened in the arbitration, that particular decision of the arbitral tribunal had no impact whatsoever in the final decision. None. So I totally disagree. And the second mistake that the Council of State incurs in is that it reinterprets the interpretation of the arbitrators as to how the procedural order should apply. And I think that's totally wrong. The arbitrators are the only ones who can interpret their own procedural rule. What the court has to do is to determine whether or not there was a violation of the rule, but reinterpret what the arbitrators did, I think is a gross mistake. And I think that there are two very good dissenting opinions that hopefully will mark the trend for the future.
Thank you, Eduardo. María Angélica, would you share your thoughts and views on this topic, please, or any remark?
No, not specifically on this topic. I would like to remark probably on something that was mentioned before. I mean, I think both you, Natalia, and Eduardo were mentioning about the need of sort of having broader and deeper conversation among arbitration and the judiciary. And perhaps something that I would like to stress is that I do believe that it's crucial for the future of arbitration that this conversation takes place and that we deepen the relationship and that we understand that we both need each other. I don't feel that we have on one side arbitration and another side the judiciary, because I think they both make sense in the context of a whole set of dispute resolution alternatives that exist for parties and that accommodate to the different circumstances of the case. Arbitration is not preferable in every single case, as we all know. In some cases it is, in others it's preferable to have access to the judiciary. So I do think that this conversation is something on which we really need to deepen and on which we really need to take a very constructive view, because I think that we need to hear the concerns of both parties. And that I believe is crucial for the future of arbitration and for the future of Colombia also as a seat for international arbitration and for domestic arbitration as well.
Yeah, I fully concur with that. And I would make just an additional remark, and is that for purposes of that, we have to involve judges in other more advanced jurisdiction who can interact with judges in Colombia. Because if we, as practitioners in arbitration, go to the judges and approach the judges, they would likely say, well, why is María Angélica explaining me this where she had a case here or she has a case, she has an interest in what she's doing. But if we bring here judges from, I don't know, France, the US, probably Peru, I don't know, and make them interact, as opposed to arbitrators and practitioners preaching to arbitrators and practitioners, I fully concur. That is a key issue in Colombia. If we don't do that, the future of arbitration is seriously compromised.
Well, María Angélica and Eduardo, we had remaining topics, but our time is up. I wanted to thank you both for your time and everyone, and now I'll pass the word to Uruguay and especially to my colleague, Mateo Verdías.
Thank you both.
A pleasure. Thank you, Natalia, María Angélica. Great to see you both.
Take care.
Take care.
So hello, everyone. Thank you very much for joining us to get to know a little bit about the Uruguayan state of play of arbitration. Today, we have with us two excellent arbitration practitioners from Uruguay, Mrs. Sandra González and Mrs. Pilar Álvarez. Sandra is a partner and co-head of the litigation and arbitration department of Ferrer Abogados, where she practices both commercial and investment arbitration. She's also a vice president of the ICC Court of Arbitration and is one of the co-founders of Women Weigh in Arbitration. Pilar is an associate at Gallar Bani Fatemi Shelvaya Disputes, where she specializes both in investment and commercial arbitrations. Before joining GBS, Pilar worked as a legal counsel for the Uruguayan presidency, and before that, she worked as an associate at Sherman Sterling in its Paris office. So having introduced our two excellent panelists, I will now address the first topic. Is Uruguay a pro-arbitration jurisdiction? Maybe, Pilar, you could start by addressing the current legal framework, rules, and institutional presence in Uruguay. Thank you. I think you're on mute, Pili.
Oh, thank you so much. Apologies. Many thanks, Mateo, for your kind words and your introduction. And I would also like to share with my colleagues their thanks to CAM-CCBC and to the Colombia International Arbitration Association for the invitation and for the initiative to give place to an event relating to arbitration with a particular focus in Latin America, which, as we all know, has shown an increasing acceptance and preference for arbitration even as an efficient method for alternative dispute resolution. Now, to answer your question, Mateo, historically, Uruguay has been a contracting party to the main international instruments pertaining to arbitration, including, of course, the New York Convention of 1958, to which Uruguay adhered in 1981, the Montevideo Treaties on International Procedural Law of 1889 and 1940, the Inter-American Convention on International Commercial Arbitration and on the extraterritorial validity of foreign judgments and arbitral awards, and the Mercosur International Commercial Arbitration Agreement, among other instruments. So Uruguay has shown a tendency towards being open to the international legal framework, and particularly the legal framework pertaining to arbitration. However, until relatively recently, Uruguay has had an outstanding debt, which was the approval of its very own international commercial arbitration law. Thankfully, to the tranquility of the arbitration community, this landmark has been achieved in 2018 with the sanction of law number 19,636 of international commercial arbitration, an event that has been, of course, very much celebrated by the local arbitration community. This law, which is based to a large extent on the ancestral model law, has consolidated Uruguay's legal framework and its solid foundations that have been previously established by case law as an arbitration-friendly jurisdiction. So my answer would be that now and after this conquest and this answer to a reiterated claim by the arbitration community, that Uruguay is indeed a pro-arbitration jurisdiction. So as from 2018, with the enactment of the international arbitration law, Uruguay has had state-of-the-art legislation providing for a dualistic system by which domestic arbitration is governed by the local civil procedure code with the provisions that have been in place for a long time now, while international commercial arbitration has its own specific regulation, which is in every sense in line with international standards. So we are very, very grateful for this great progress. As another step forward, in 2020, a new private international law was enacted in Uruguay, which allowed for choice of law clauses in international contracts. This was previously prohibited under the private international provisions under the Uruguayan Civil Code, as is the case of many jurisdictions. I understand even this is the case for Brazil. And this has also proven to be, as I was saying, another step forward, another display of Uruguay's will to make progress in its towards a full modernization and internationalization of its legal order. And it has removed what many of us thought was the last legal issue of concern regarding Uruguay's ability to serve as a bulletproof venue, as a bulletproof seat for international arbitration proceedings. Also, Uruguay has a very solid arbitral institution, which is the Center for Mediation and Arbitration, Mercosur International Arbitration Court of the National Chamber of Commerce and Services. This center has been functioning as an arbitral institution since 1995. So it boasts a pretty long record providing efficient alternative dispute resolution services, both in the local and regional markets, with a particular focus on Mercosur. Last year, the approval of its brand new arbitration and mediation rules was definitely one of the most celebrated events in the local arbitration calendar, having it been presented in a conference with the participation of highly renowned Uruguayan arbitration practitioners, including Sandra, who is joining us today. The new rules were elaborated in line with main international trends in terms of arbitration rules, having been inspired by the rules of the most salient arbitral institutions in the world. So once again, Uruguay is getting up to speed and really putting its framework regarding arbitration at the highest standards. Some of the new features of the arbitration rules are the possibility of conducting virtual hearings, which, as our colleagues were referring to before, and after the thanks to the COVID pandemic, its importance we have all come to appreciate, I'm sure. Other provisions include state-of-the-art provisions regarding multi-party and multi-contract arbitration, which were lacking in the previous version of the arbitration rules, and which are particularly important regarding complex arbitrations, and for example, the area of construction disputes. There are also provisions that put in place increased transparency and disclosure obligations, which are also a very current concern, and the possibility to conduct emergency arbitration proceedings for interim relief. This innovation has also been received with much optimism by local arbitration practitioners, among which I count myself as being confident that the new arbitration rules, together with the new arbitration rules, will be an important, with the new arbitration law, will be an important tool towards promoting Uruguay as an arbitral venue of choice in the region, and as a definitely arbitration-friendly jurisdiction.
Thank you very much, Pilar. That was very clear, descriptive, and encouraging indeed. But now let's switch from the regulatory standpoint to how courts have applied these regulations. Sandra, would you like to comment a little bit about the Uruguayan jurisprudence on arbitration?
Thank you, Mateo. And I would like to join Pilar in thanking first the Colombia International Arbitration Association and the CAM-CCBC for the invitation. It's an honor to join our colleagues and you, Mateo and Pilar in particular, because we share nationality and certainly the desire and willingness to help Uruguay become trusted as an arbitration seat and as a place for development of international arbitration and domestic arbitration as well. I totally agree with Pilar. This state-of-the-art laws and regulations, both coming from the new rules of the local center of arbitration and also the laws, international law and the arbitration law, the international arbitration law, were absolutely necessary if we wanted to actually be able to mark with a tick Uruguay has state-of-the-art regulations. This was necessary. It's not sufficient. And what we need now is a state-of-the-art application of both, the regulations in terms of the rules applicable to arbitrations when Uruguay is a seat, and also the judiciary's application of the laws that we have. I must say that and this may seem a paradox, but I was more optimistic before than I am now with having seen decisions recently that are more or could be a setback in our path towards being or consolidating more likely as a friendly jurisdiction to arbitration. Now, before we had the laws, and in particular the international arbitration law, we certainly had a precedent that consolidated this friendly approach that Uruguay had towards arbitration. And so you would see that even absent an international arbitration law, the courts were respectful about not interfering with the merits of awards, both in nullity proceedings and enforcement proceedings. And for that, they very much apply the New York Convention, which was another treaties that Uruguay is a party to. So it was, in a way, I think there was internationalization of standards applicable to arbitration. And precedents were well aligned with the most modern tendencies in that sense. Now, I think it's probably a coincidence. I don't think it has nothing to do with the fact that we have these new laws, but we have had, and I think this is part of what we are going to discuss next, we have had a few decisions that have raised some concerns in the arbitration community about what lies ahead. And in particular, I think we should take them as what we still need to do. You are muted, Mateo.
Sorry, thank you very much. Thank you both. I do believe that we have a growing and solid grounds to affirm that Uruguay is a pro-arbitration jurisdiction. But now we will talk about the second topic, which is pretty much related, which is Uruguay an attractive arbitration seat? And considering the elements that make an arbitration seat attractive. So Sandra, do you have a specific view on this point?
I think that we do have advantages, in particular to become a regional center, and becoming a regional seat that is attractive for other countries that are considered to be giants in terms of the cases that may have because of their economic activity, and so we have seen in the past cases in which, for example, you have Brazilian and Argentine companies that take a look at Montevideo as the seat of a potential arbitration, and we have seen cases in which arbitrations materialize in this type of context. And in my view, there are two main reasons why Uruguay is attractive and should and could be even more attractive. Number one is that it's neutral because we're a small country and that has advantages and disadvantages. This is one advantage, which is we're in the middle of Brazil and Argentina. We are also relatively close in a cultural sense to other places, to other jurisdictions in Latin America. And that should give us the neutrality that we want to offer. That is that the Uruguay may be seen as, okay, this is a place that's not that's a neutral seat, and that's always important for parties. And then the other thing is that our judiciary, that in the end is the one that's going to be called to decide on certain very relevant issues about arbitration proceedings and the results of arbitration, have a reputation and a well-deserved reputation of being independent. And I'm not going to say that there's no corruption at all, because to a certain extent there must be some in every country. But our judiciary is certainly well known for not being susceptible to political pressure or economic pressure, and I think that our track record shows that this is true, and that cannot be said about every place in Latin America. We have political stability, and that is also something that I think should be attractive, because this means that courts and very important roles in the judiciary do not change depending on which political party is in charge, and that I think contributes to this independence of our judiciary. This, in my view, these two issues are the ones that contribute the most for us to being attractive.
Excellent, Sandra, thank you very much. I do agree that those elements are key, and we do have them. But are there any other elements that we should improve in order to make ourselves a better and more attractive seat of arbitration? Pili, do you have any view on this end?
Yes, thank you, Mateo. And actually, to answer your question, I would like to pick up on what Sandra was saying earlier today, which I absolutely agree with, which is that now that we have completed the checklist of the rules and regulations that Uruguay has to have in place in order to be an attractive venue and seat for international arbitrations, we have to take a look at the people who are applying these rules and regulations, and how their understanding, how deep their understanding of the way that international arbitration works goes, right? So I do believe that although we are up to speed with the subject of legal reforms, we should focus now on strengthening legal education in terms of the specifics of arbitration, both at a graduate and postgraduate levels for attorneys, for practitioners, and also for judges and clerks, and even most importantly, for judges and clerks. They are, in fact, in the end, the custodians of how an arbitration system works, right? Because they will ensure ultimately that it gives results that are in line with the parties' expectations and in line with technically correct standards. As we all know, international commercial arbitration presents several characteristics that are unique to the field and which may be technically challenging, such as understanding arbitrability or the intersection of different bodies of law, how they work together, the relevance that certain soft law instruments may have, which is completely alien to how domestic proceedings normally work, procedural flexibility and the use that we do of mixed techniques from common law and civil law, or even the function and scope of annulment proceedings, to name but a few of the most salient and challenging technical issues that we face. So as a result, the adequate formation of lawyers and judges is crucial to ensure that the system functions without 11th hour surprises, with the ensuing increases in delays, costs, and legal uncertainty, and with the unpopularity that it unjustly brings to arbitration as a method for ADR. As Sandra was saying, the Uruguayan judiciary is very well known for its independence, for its reliability, and it would be marvelous if it could be also renowned for its specialized knowledge and its understanding of the complexities of arbitration and the important yet limited role that domestic courts have within the system. And I believe that this is particularly relevant in our current context because we actually have to make up for lost time. Uruguay only very recently approved its international commercial arbitration law, and we cannot afford to waste any more time in decisions that are not in line with the modern parameters that are actually in place in Uruguay at the moment. So we have to really work and concentrate our efforts on making sure that practitioners know the law, that judges know the law, that they know how to apply it to make the most of this newly minted arbitration law. In this sense, I would also like to highlight as something that I believe is very positive, which is that the universities, different universities in Uruguay are trying to focus their energies in arbitration more, to include arbitration as part of their programs, to support their students and their involvement in the international arbitration competitions, which, as we know, may be the opening door for career in arbitration. And I believe that is, although there is room for improvement, that has been there has been progress in recent years in this regard.
Thank you, Pili. Thank you both. We have indeed to keep working both from a legal standpoint, but also from a cultural and educational one in order to keep growing Uruguay as an attractive arbitration seat. But we will now refer to a case that many refer to as a step back, the UR case. I will not advance its content as I believe Sandra will be able to explain it better. Sandra, the floor is yours. You're muted.
Yeah, here. Yes, it was my turn actually to be muted, right? Because it was Pilar first and then you. So it just there needs to be one turn for each participant. That we've learned from this world that we are living in. Full disclosure, I represent Uber in these cases in Uruguay, so that is the first I need to clarify. Now, this is a case that is not unique to Uruguay in the sense that we have seen it in other jurisdictions. As you know, Uber has contracts with the drivers, and in those contracts, in general, I cannot say that in each and every case that's what happens, but at least it is the case in Uruguay. In those contracts, there is an arbitration provision, and arbitration has a seat in Europe, and there's certain rules, and that's basically how it is, how the arbitration provision is drafted. My understanding is that there are similar cases or identical cases, for example, in Canada, in a jurisdiction in which this was also debated. As you may imagine, because we have seen it in Uruguay and in many other places, drivers, or at least some drivers, consider themselves to be employees as opposed to contracting parties, non-employee contracting parties. So they have, in Uruguay, they have filed claims against Uber, arguing that because they are employees, they need to receive certain labor benefits. And the company, one of the defenses by Uber is that there's an arbitration provision, and therefore the courts of Uruguay are not competent to hear these cases. or at least the court should remand the cases to the arbitration tribunals, and due to the competence principle, then the arbitration tribunal should decide whether or not the other concerns that might be around the arbitration provision. Now, up to now, courts in Uruguay have consistently rejected the objection to their jurisdiction filed by the company, arguing that individual labor relations, such as the one between drivers and the company, are excluded from arbitration, or better put, these are relations that are sort of reserved for the jurisdiction of the Uruguayan courts, because the Uruguayan courts offer a protection that is not waivable, and they understand that an arbitration provision in a way would be read as a waiver to a special protection of the law that is the one that the courts maintain is only offered by the courts and could not be achieved in arbitration. Now, the basic reasoning behind this is that labor relations are under the special protection of the law and the Constitution. The courts have actually argued that the constitutionality block, as they call it, which protects employees, is applicable here. Now, the problem, and something I must say, is that these decisions have been consistent in both first instance and courts of appeals, but we need to remember, and I think this is important, that this comes from labor courts, which are courts that do not normally have to decide cases in which arbitration clauses are part of the mix. That is an important thing, because this is a special set of courts, and they apply to a certain extent principles that we all know from labor laws are very particular and very special. Now, so this has been a reason for concern in the arbitration community in the country, in particular because the conclusion of the court seemed to be that the whole area of labor relations is excluded from arbitration. And before these decisions, we had a Supreme Court decision in which the Supreme Court had affirmed, not unanimously, and the court's integration has changed, but still, it was a decision by the Supreme Court ratifying that in a particular case in which a labor relationship was being discussed between a company and a sports coach, it was decided that arbitration was actually completely admissible in that case, and that was a labor relation of a different nature. We may discuss or with different characteristics, and there was a case before then, not by the Supreme Court, but affirmed by a court of appeals, in which there was a labor relationship between a company and a consultant, and arbitration, and the courts in Uruguay actually remanded the parties to arbitration. So up until this particular set of cases, there was no question in Uruguay that labor relationships could go to arbitration. That doesn't mean that in every case it had to be accepted, but there was no general exclusion of the subject matter of the cases, because those were labor cases. That means that they are excluded from arbitration. And the other reason of concern is that if you are going to argue that something is under special protection of the Constitution of the law, I don't think how anything that's related to the property rights should go necessarily, or can go to arbitration, because that's also protected by the Constitution, because you have many constitutional provisions that provide certain specific protections to other rights, not just the right to work. So this, in my view, this is because the reasoning, I think, is faulty. I don't think this is the right way to go, and I think that the reason for this, as I was saying, is the fact that this, you know, the labor courts are a little bit more devoted to their special subject matter and how it is under special protection, as opposed to a more reasonable approach in terms of, okay, when an arbitration provision may proceed and when it may not. And you can draw a distinction with the approach in Canada. In Canada, there was, I think, in the end, the decisions were similar in the sense that the arbitration provisions did not proceed. In the cases were decided under the courts. But the distinction is that in Canada, there was a discussion about whether consent to arbitrate was proper or not and was valid or not, which is a way in which it could have been approached in Uruguay. And in my view, a more reasonable, more sensible, and the legal and correct way to go, actually, and not by excluding a set of relations from arbitration. And the reasons that I think tend to be that the protection of the courts, of the judicial courts, it's in a way superior to the ones of the arbitral tribunals.
Thank you very much, Sandra. A very clear explanation. And I do believe this was an isolated and very specific kind of case that doesn't prevent us from affirming that Uruguay is still a pro-arbitration jurisdiction. Now, because time is of essence, final reflection concerning the Uruguayan market. Sandra, do you believe that, do you have any view or thought as to the growing number, if any, of the cases and the possibilities they represent for Uruguayan arbitration practitioners?
They grow by the hour. That's what we are seeing. And it's not just in terms of the numbers of cases that we have, but also in terms of the arbitration provisions that we see our clients include in their contracts. It used to be for international contracts only, but now you see it in domestic contexts, in cases or in contracts or commercial relationships that you had not thought 5-10 years ago. It's growing by the hour, I think. And there is, but what happens is that the community, the arbitration community, I don't think is yet up to speed with this growing tendency. I think that you know, it's a mix of reasons. One is that, as Pilar was saying before, and I completely agree, we still need to you know, increase training in arbitration in universities. This cannot be just for the teams that go to the competitions, because that is too small for the needs of the market. And then judges are essential. We need to educate judges. That is, in my view, at least, something that is missing. There seems to be a disconnect. Judges do not receive any kind of training in their training to be judges about arbitration. And this is something that they are going to see more and more.
Excellent. Growing by the hour and with the need of further legal education. Very clear. And finally, Pilar, would you like to share your thoughts and experience as to the job opportunities that young attorneys have both in Uruguay and internationally?
I remember to unmute my microphone before speaking, better late than never. Thank you, Mateo. Of course, certainly. And although Uruguay is, of course, a much smaller market compared to other Latin American jurisdictions, Brazil, Argentina, Colombia, to name but a few, I do believe that young Uruguayan lawyers have several ways to make the most of the opportunities available both in Uruguay and abroad to further their careers in arbitration. This is not impossible by any means. First, as Sandra was saying, arbitration cases involving Uruguay in some way or another are increasing. It's a fact that is impossible to deny at this stage. And so the incorporation of lawyers specialized in arbitration has become a must for local firms. Be it either as local or as lead counsel, local firms may certainly offer a path for young lawyers pursuing a career in arbitration towards obtaining experience. And in addition, I believe that also an increasingly promising path towards a career in arbitration may be as internal counsel for companies, in particular international companies with headquarters in Uruguay. It is a well-known fact that during the last few years, more and more companies have chosen to relocate either a part or the totality of their operations and or management to Uruguay, including in many cases their legal teams, and the possibilities of participating in major arbitrations have increased hand in hand with this tendency. So this is certainly, I would say, a path that is on the rise for opportunities for careers in arbitration. Beyond these possibilities, considering the quality legal education existing in Uruguay, regardless of the limitations that we have mentioned before, opportunities abroad are also endless. And I would really like to encourage any young lawyers who may be listening in on this conversation to pursue opportunities abroad. The doors are wide open. In my specific case, I started becoming specialized in arbitration after having found out through a Uruguayan colleague working abroad of the possibility of applying for an internship at the International Arbitration Department of Sherman & Sterling in Paris. I believed I stood no chance at all. But in the end, I got into the internship program, and then I continued to be hired as an associate, and I worked for 2 years with the team at Sherman & Sterling, and that actually allowed me to later access a unique opportunity to work as a legal advisor for the Uruguayan government in matters relating to international arbitration, specifically in the investment arbitrations against Uruguay. And currently I have joined GBS Disputes, which is this firm that's an international firm specialized in arbitration, formed by part of the former Sherman & Sterling team. So as I was saying, just this step forward and this attempt several years ago to pursue an opportunity abroad actually opened all these doors in the way forward. So really, I would just like to give this piece of advice today, which is that, do not be afraid to contact colleagues abroad. Do not be afraid to query about any opportunities that they might know of. And do not be afraid to trust yourself, send your CV. As I was saying before, the world has its doors open. And if you're motivated and committed, you will certainly succeed.
Can I just say something? Because Pilar was mentioning something that I had this idea. I think that one of the things that Uruguay can do to improve the community and move forward with arbitration is that I think something that happens is that the government needs to offer a more stable career in arbitration for professionals. We don't have a procuraduría, and in some countries in which you do have that, say Colombia, because we've just heard from Eduardo and María Angélica, that is a tremendous help to promoting arbitration and to offer careers to people that want to do it professionally. And I think that that's something that we need to start thinking about.
Absolutely. And actually it's in the interest of our country as well, right?
Exactly.
Professional or legal advisory specialized in arbitration. I completely agree.
Yes, thank you both. That would be fantastic indeed. And now, because our time is up, we will now conclude our panel with many thanks to Sandra and Pilar, and inviting you all to stay tuned for the fourth and last panel of the day regarding arbitration in Argentina. Will be moderated by my good friend, Luis Tamborini. Luis, the floor is yours. Thank you very much.
Thank you so much, Mateo. And a special thanks for our attendees. We know that Zoom fatigue, it's real, and we are almost in 2 hours time, but I promise we'll keep this interesting, and how not to if we have two amazing panelists with us. Here it is, Silvia Marchilli. She's a partner at White & Case at the Houston office. She has almost 20 years of experience focusing on complex international arbitration cases involving investment and commercial claims. She handles matters involving Latin America and Africa in a diversity of sectors, and she has been ranked as an expert in dispute resolution and a leading practitioner in Latin America. We also have Ignacio Minorini Lima. He's a partner at Bruchu, Fernandez Madero, and Lombardi in Buenos Aires. He's the head of the Administrative and Regulatory Law Department and leads the arbitration practice at the firm, with also extensive experience in both commercial and investment cases, also a ranked practitioner in the field. And I have to say, one of the best attorneys I had the privilege of working with in the past. So Silvia, Ignacio, thank you so much for taking the time to join us and review with us the state of play of arbitration in Argentina. Please feel free to interrupt each other in the panel as much as you want, disagree on whatever you feel of disagreeing. Let's keep this dynamic. Let's do it Argentine style. And with that, a short introduction for our attendees. As many might know, Argentina is known for its soccer, tango, and economic crisis. However, business, it's ongoing. To some extent, there are foreign investments, and we can see certain industries growing, others shrinking. And it is important this for arbitration because from this business activity, dispute arise, and with the dispute, the arbitration practice develops. So perhaps, and Ignacio, it might be useful if you could give us a sense of what cases you have been handling in the past few years, so we can have a brief overview of what is going on in Argentina lately.
Thank you, Luis. Hello, everybody. First of all, let me thank the Center for Arbitration and Mediation of the Chamber of Commerce, Brazil, Canada, and the Colombian International Arbitration Association for the invitation to speak at this event. I like the approach that you would like to take more a commercial approach towards arbitration rather than a more legal one. So let me start with a proposition. I think that everyone would agree that in order for arbitration to develop, we need, first of all, investments. So a humble motto would be no disputes without investments, without commercial activity. And I think that this principle applies across the globe, but Argentina is the perfect example. Let's take, for instance, in the last 5 years, the situation of renewable energy in the country. Since 2015, 2016, Argentina promoted a renewable energy program in Argentina. In these last 5 years, more than 150 projects were developed in the country, and that 2 years afterwards triggered some disputes with the off-taker, disputes with suppliers, disputes with landowners, and construction disputes. So even if the project reached commercial operation and was successful, 1 or 2 disputes, pre-disputes or actual disputes, were there and were to be settled through arbitration. And if the project failed, and of course some project failed, we had at least 4 or 5 disputes per project. All these disputes were settled also through arbitration. And I assume that if we go to other sectors, and I'm sure, Silvia, you may jump in here with other examples, we're gonna find out that arbitrations are followed, investments are followed by arbitrations. I don't know, Silvia, if you'd like to comment also on this, particularly in the energy field.
Happy to, if Luis is okay with that. We are going to interrupt each other because apart from being Argentines, we are friends. So thank you all again for inviting me to participate. And you have to excuse my informal attire, but I'm sailing the Keys with the family. So I'll apologize in advance also for any background noise.
You're in a better situation than ourselves then.
Maybe, but not for a webinar. Anyway, I completely agree. The way I put it typically is disputes follow money, right? So it is only when you have an influx of funds, especially usually from overseas, that leads eventually to disputes. Now, and there are, I think, 2 variants. If there's government intervention that leads to disputes more in the treaty arbitration world, and if that is not the case, that typically leads to commercial disputes, whether M&A or just contractual disputes. But the situation in Argentina indeed has been a bit stagnant, I would say, with respect to FDI. We have not seen the massive influx of FDI for direct investment that we've seen in the 90s ever again. The two, I don't know to call them exceptions, but areas in which we were gearing, at least directionally, towards those investments have been, I think, Vaca Muerta, and as Ignacio was mentioning, the renewals projects that were implemented and to some extent executed during the Macri administration. Now, Vaca Muerta is an interesting example. We've had foreign direct investment there, especially in exploration and production for the last 10 years now. And that certainly generated significant, had an impact on the country's GDP. At the same time, and try to stay just focus on the commercial aspect of it, and then we'll get to disputes. But it has also become a little bit stagnant because of a reason, and that is that pretty obvious one, which is how to market, especially the natural gas that is being pumped in Vaca Muerta. Local market cannot absorb and does not justify massive investments to continue to develop those wells. You need to export them. And because it is gas, you have to either, basically you need to have either petrochemical and some other projects nearby that would develop it, use the natural gas to develop other products, or you need to export it. And to export it, you need a gas pipeline, right? That would take that gas all the way to the shore and then have a liquefaction plant. Now, maybe 5 years ago, there was a lot of interest in Argentina developing that gas pipeline. LNG project, which is liquefied natural gas, is a very sophisticated, attractive type of project for investors. But while there was the meeting terms and conditions for that gas pipeline at some point were almost approved, that never materialized. So that that has certainly hindered the ability of the producers there to really expand and for the country to receive those massive investments. Now, I must say that in the last few weeks, there have been some new developments there. The state has launched a trust fund, or announced that it will. So it will be a trust fund led by state-run and state finance, most importantly, that would, in theory, build that gas pipeline. And I know that just a couple of days ago, the CEO of one of the leading Argentine E&P companies has proposed that another trust fund be created, led by YPF, to build the liquefaction plant. But we are talking about investments in the dozens of billions of dollars, which require a clear signal and commitment from the government, close to non-government intervention or government taking risks, which is, of course, in Argentina, a bit of a challenge. But I'll stop there, just in case Ignacio want to keep developing the point that you were making before.
While you were speaking, I was asking myself, what's the role of arbitration in the context of these investments? And I remember when the renewable energy program was being designed, I mean, the first draft bidding terms and conditions and the first PPA that the government issued had no arbitration provision. And there was a meeting at that time with the banking institution that at the end of the day were going to finance those projects, that said, if you want this to move forward in a successful way, you need to include arbitration as a settlement dispute mechanism. And the government at that time, the Macri administration, changed the approach, removed the dispute resolution clause that at that time was pointing to the commercial courts, and included an international arbitration provision. And I wouldn't say that was, I mean, the first condition that the banks were looking into, but it was a material condition for the banks. to promote and foster financing. And the same happens now. I mean, if you were talking, Silvia, about LNG projects in Argentina would take like $4 or $5 billion to implement. And we need heavy financing for that. And in order to promote that financing, what we need is the conditions to be there, the legal conditions to be there. We need legal certainty in first place, but also we need an independent dispute settlement mechanism. And that would be arbitration. And we need, arbitration pointed to institutions with an excellent track record. But Luis, I don't want to continue and interrupt what.
No. That's I was passing the floors to you back to you because of that. But sorry, Luis, you were going to say something.
No, that's perfect. And I mean, we're focusing a little on the regulated market in Argentina and the role of commercial and state arbitration, the differences. Silvia, you mentioned this investment of the 90s. We know how the experience of Argentina then in the 2000s with respect to those investments and arbitration. Now, Ignacio, you mentioned that there's been a shift now and the state is including again arbitration clauses in certain programs. Now, with respect to the economic crisis that Argentina is being dealing with and how it's being dealing with, for instance, foreign exchange market restrictions and provisions of the like, I would like if you could introduce us a little on the experience regarding the effects of the measures that the Argentine government has been implemented both in non-regulated markets and regulated markets, and what kind of arbitration-related work this cost. Maybe focus now on non-regulated markets. What is the experience that you have been seeing with respect to arbitration in companies in non-regulated markets? And I think I could give the floor to Silvia if she wants, but Ignacio, feel free to comment.
Maybe I can say a couple of words and then pass the floor to Ignacio. My answer, I will start with a question actually, which is, what is a regulated market in Argentina? What is a non-regulated market in Argentina, right? And that goes to the risk that we were identifying before. If you're going to have price controls, if you're going to have foreign exchange intervention, and if, as it happened, I think it was basically almost 2 years ago in the telecommunications sector, becoming a regulated sector by decree overnight and without any clear parameter, it's hard really to predict what is a regulated market and what it is not. In terms of what it has meant for the arbitration portfolio, so to speak, in the country, I'll say a couple of words, but I'm sure that Ignacio will have a lot of value to add there as well. In terms of treaty disputes, I would say that we have some legacy claims that come from those investments in the 90s or in the early 2000s that has, for some reason, each of those, and there are various different reasons, each of those investors really still hope that with time, the government would sit down at the table and try to reach a settlement. And after many years of that not happening and getting closer to the end of the concessions, they decided to pull the trigger of investment cases. Those are typically in treaty arbitrations in regulated, purely regulated sectors. But again, what is regulated and what isn't? A couple of those cases are in the power generation sector, which in theory should not have been regulated and has been for many years now. But as to those sectors that are not regulated, I would say that I've seen an uptick in the commercial arbitration cases, especially in construction, arising from the renewal project. So right now, for example, I'm handling 2 cases involving foreign companies with projects in Argentina that have been, in many cases, completed those plans, but there's still delays and change order disputes arising from them. So that's what I've seen. Just a few, legacy claims from the prior wave of investments, and then construction cases arising from the renewal projects that were in the making for the last few years. But Ignacio, I'm sure you've seen more and more varied.
I fully agree with you that it's impossible in Argentina to find a sector that is unregulated. So almost all sectors of the economy in Argentina are somehow regulated one way or the other. It is correct, as you say, that there were some general measures like Lucho, you were mentioning the FX restriction, but also the pandemic. I mean, the regulations that the government issued with respect to the pandemic that had a strong impact on ongoing agreements, on LNG agreements, on construction agreements, and renewable energy agreements. And these issues trigger disputes, construction disputes with respect to delays, and whether or not the pandemic regulations qualified as force majeure events or not. We've been working heavily on that with Lucho. You remember those cases at the early stages. And then with respect to FX restrictions, that prevented many companies from making payments in US dollars abroad, and that triggered disputes with suppliers in import operations. That, of course, that came from the government, but impacted on purely non-regulated markets. Then we have, like Silvia mentioned, the pure regulated markets like power generation, power distribution, gas distribution, gas transmission, electricity transmission, in which what we have seen now is as the government since 2002 up to today has not yet renegotiated in full the public utilities agreement, and by renegotiated in full, I'm referring to reaching a renegotiation agreement and then implemented in full that renegotiation agreement. We're still facing some issues with respect to the adjustment of public utilities tariffs, and that leads to the companies looking at the possibility of initiating or resuming investment arbitration cases against Argentina. I mean, in general, the companies resort to investment arbitration as a last resort remedy when they see that there's nothing left to be done. But prior to that, they search, for instance, for Silvia and ask Silvia, what should I do in order to not affect the possibility of going into an investment arbitration? So at the same time that they are negotiating with the government, they're looking at the possibility that those negotiations fail and they need to resort to arbitration. They want not to take any steps in the negotiations that may hinder the possibility of resorting to arbitration.
And Silvia, if I may, because I want to take advantage that we have a partner from a law firm in Argentina and a partner from an international law firm that it's based in the US. So in the handling of these cases, Ignacio and Silvia, when does the firm like White & Case or other international law firms get into the case in Argentina? We mentioned that there have been some commercial cases going on. We mentioned the potentiality of having an investment claim against the country. I would like to see a division of when it's the case is handled by Argentinian law firms and when does an international law firm come into play in a common case in arbitration in Argentina.
I don't have statistics. I have just a hunch and a view of how the companies take this approach. But I would say that you have companies that had experience in initiating cases against Argentina. So they already have like their selective law firm from the US. So when they see that there is a chance of having a new investment arbitration case, they know to whom they need to resort in a foreign law firm. Then you have other companies that had no experience in the past with investment cases. So usually they knock the door of the local law firm in order to find out how this animal works and what they should do or shouldn't do. And that is as a first step. And as a second step, they hire international counsel. So I don't know, Silvia, what are your views on this?
Yes, no, that's an excellent question, Luis, and I agree with Ignacio in general. what we have seen in Argentina to some extent, but we see more and more in other jurisdictions, and the reason for that is because more disputes, especially treaty disputes, are arising in other jurisdictions, is that we really come in not as an arbitration council, but as a strategist, right? So ideally, the scenario is, and we've been doing that, it has taken quite a bit of my life for the last couple of years doing that pre-dispute work, for example, in Mexico, where the government has been passing first regulations, then in an increscendo mode, a law, and then a constitutional reform that will significantly impact the investments in especially the power sector, although the oil and gas sector has been going through some threats as well. And so what we do is that even before they consider pulling the trigger and going to arbitration, is to work with the in-house counsel, local counsel, to understand what's their commercial objective, right? And of course, those come in every shape and form, but we try to then align various aspects, right? We try to make sure that, one, they know whether they have international rights or not, what to do to preserve them, how any, for example, local action may have an impact on those international claims in the future, but also with a view to maximize the chances of the investors settling their claim in advance, right? And that's where I was, making the point that, clients should think of Luis, Ignacio, and myself not as, the guys or the team that comes when a notice of dispute is about to be filed to draft it. It's much more than that. And, in many cases, we've been very successful in trying to, in actually having the claim settled before any arbitration paper was filed. But I always describe, maybe it's not a great analogy, but the way I describe it to clients is that it's as if you're playing chess, but on 5 or 6 or 7 dimensions, right? So every time you move a piece, if you're not aware of all the other dimensions, you may be hindering your own rights, you may be losing an opportunity, and so on. So it's very important to come up with a plan, have an action plan that is consistent with all of those rights, and then take it from there. Even if arbitration is not even your last resource, it's like literally, plan Z. It's still very advisable to start planning and thinking about it from day one.
And in most of the cases, as Silvia was saying, the companies want to reach an amicable settlement and continue doing business in Mexico, in Argentina, in whichever country they're doing business. It is not the purpose of seeking investment arbitration to reach an award that then they have years and years in order to enforce that award and get paid. It's a way to tell the government that they want to settle the matter, but if they cannot do it through an amicable way, they have the means of arbitration.
And perhaps now jumping a little bit to the law, since we're lawyers. In 2017, Argentina enacted its International Commercial Arbitration Act. At the time it was written, there was a lot of discussion, panels, papers were written. Now almost 5 years have passed, and I would like to see your views on the practical impact of this law now that 5 years has passed. Did it change the perception of arbitration in the country? Was it useful tool to promote arbitration in the country? We discussed, for example, the inclusion of arbitral clauses in renewable energy programs, in PPP programs. Was this somehow related to the enactment of this law, or was it by chance? What are your opinion on the effects of this law? Ignacio, if you would like to start.
Yeah, sure. I think that the development of arbitration in Argentina is a process that started long ago. The passing of the International Commercial Arbitration Law was an important event in that process and helped continue fostering arbitration. For law firms, it was like a marketing tool in order to promote arbitration and to convince our clients to insert arbitration clauses in their agreements. At at the same time that the government promoted this international commercial arbitration law, which was, which followed the UNCITRAL model law, at the same time the government was including arbitration agreements in state promoted agreements like the PPA in renewables, like the PPP projects. So I think that there are several factors that help in promoting arbitration. What we have seen, and this is something that we work every day at Bruchu, is that in almost all M&A agreement, we include an arbitration clause. In almost all supply agreement that I would say above $10 million, you have an arbitration agreement. Could be domestic, could be international. I think we still have a challenge in Argentina to promote and to help domestic institutions to grow. We have very important institutions like the CEMAR, the SEMA, the Stock Exchange Arbitral Tribunal, that have been working in the field for many, many years, but they still need to capture most of the domestic disputes and leave the big players like the ICC, the PCA, for the real international cases. And I will talk later about jurisprudence on that, but maybe Silvia would like to comment first.
Yeah, sure, happy to. So I think that, when thinking about our arbitration in Argentina, you can look at it from different perspectives, right? One is, do Argentine parties or Argentine related contracts provide for arbitration, right? That's number one. Whether it's, then you have the issue whether it's a seat or not, but that's, is arbitration a well-known dispute resolution mechanism or is it not? I think that it is, and the issue there too is that because of the significant development in treaty arbitration over the years, for many years arbitration was associated with investment arbitration, and like in other jurisdictions where the awareness was first raised with commercial cases, that we somehow went the other way around, and that also created its own challenges. But so you have the issue of whether parties provide for arbitration, then Argentina or Argentine cities like Buenos Aires as a seat. That's the more challenging and, if you wish, ambitious goal. And then I would say the capabilities, right, in country. So with respect now to the second point, Buenos Aires as a city is still an incredibly hard sale, right? To be honest, if any client of mine calls me, and it happens often, and says, hey, I have this project or have this contract, which Latin American jurisdictions should I choose as a seat? Let's be blunt, I will not say Buenos Aires, right? Unless there's like a very special configuration of factors that I cannot even imagine right now.
You break my heart, Silvia.
I'm gonna challenge that, I'm gonna challenge.
Please do.
This conversation was going too smoothly. I like to keep it more controversial. I think, again, from an international perspective, it's a very hard sell, right? Now, having said that, I typically would recommend other seats even outside of Latin America, right? But if pushed, there are others like Chile, or even Bogota, or even seats in Costa Rica that are a bit more stable, or at least less risky. But I do think that over time, because of the level of sophistication, and I'm going to the third point, of the legal community in Argentina, including with respect to arbitration matters, that will change. I think it's a matter of, leaving behind the bad PR that some players have focused on developing for arbitration because of the experience in investment cases, that will really develop in the future. The law helps, but what really makes a difference is whether you have a judiciary that is, clearly in support of arbitration. That's a bottom line. But there are intermediate steps like many other jurisdictions are taking as becoming a hub for hearings, right? Again, to keep developing that arbitration culture in the market, and hopefully one day becoming a clear seat that we can all recommend.
I can understand that we are not the top 3 seats in Latin America, but we're changing. You know, with respect to arbitration in Argentina, I think that there is a huge difference between commercial cases and cases involving the state. When we go to commercial cases, we find, I would say, a consistent case law in support of arbitration. But I would say that disadvantage here for us is that the most renowned cases abroad are those cases involving the state. So in disputes with the state, I mean, it's famous, the Cartellone case that was issued by the Supreme Court in 2004, in which the Supreme Court held that awards may be reviewed if they were unreasonable or contrary to the public order. And at that time, the Supreme Court opened the door to review the merits of an award, and that case hit all the newsletters across the globe. But that jurisprudence has changed. In 2018, the Supreme Court issued a judgment in the case that is Estado Nacional Procuración del Tesoro, in which it held that awards may only be annulled based on the numerous clausus reasons established under the law, and the courts may not enter into reviewing the merits of the decision. Of course, I mean, this is a first decision issued in 2018. There is a long way to go, but I think we are on the right track. And if Argentina keeps on this good track on arbitration, I'm going to take something that Sandra said in Uruguay, that we still need for the arbitration practitioners to be closer to the judiciary in order for the judiciary to see the arbitration as an alternative means to settle dispute that is not opposed to the traditional way of resorting to the courts. But I mean, I would say that I'm optimistic that we're gonna see Buenos Aires as a seat of arbitration for international cases and not only for domestic cases in the near future. And of course, you know, as I said at the beginning, I mean, everything is regulated in Argentina. Most of the large investment projects are promoted by the government, and in state contracts, the government will most likely try to put Buenos Aires as the seat for any arbitration.
I don't know, Silvia, if you're convinced now that in the future you must advise your clients to...
You should be a little bit optimistic, at least, for the future.
Happy to be optimistic. Especially if you guys invite me for a nice dinner in Argentina, I'll be even more optimistic next time I'm there. No, I agree.
Let's wait and see.
I agree. I think that it's, there's an ongoing process of, I would say, depoliticizing arbitration in Argentina, which I think is very helpful. And again, I think that it's a very sophisticated legal community, and that together with the law and hopefully some investments coming in the near future will help us get us there.
Perfect. And Ignacio, Silvia, the event should have ended at 12. Of course, we went a little bit over because also the other panels did a little bit. But thank you so much for having us. Again, thank you for the organizers and the attendees that remained with us up to this point. I know that it was promised to end at 12. We went a little bit beyond, but I think, I hope everyone found it interesting. Silvia, Ignacio, again, thank you so much for taking the time, especially you, Silvia, on your vacations. I hope that ends well. And please stay in touch. If anyone has comments, questions, the chat is available, but if not, I've seen that no one wrote. So I think we can end the event now.
Thank you very much, Luis, Silvia. It's been great to be here with colleagues and friends, and thanks.
Perfect. Silvia.
Same here. Gracias totales.
Igual. Mucha suerte.
Thank you all. Bye-bye.
Thank you.
Bye-bye.
Bye-bye.